Good evening, everyone. Welcome. This is the Town of Somers Zoning Board of Appeals meeting. The date is February 21st, 2023. Denise, would you please take the roll?
Mr. Gio,
Here.
Mr. Hardin,
Here.
Mr. Lansky,
Here.
Mr. Newman,
Here.
Chairman Canestra.
Here. I request everybody stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everyone. I did want to mention one change I want to make to the agenda this evening. For the second item, I'm going to hear the UB Somers Inc. application, and we're going to move the blue application to number 3, just because I think this will be better for timing. Okay, so the first item on the agenda this evening is that of Jeffrey and Andrea Weisbrot. This is an application to renew a special exception use permit for an existing accessory apartment attached to an existing one-family dwelling in an R80 residential district at 128 Young Road, Katona. Is there someone here to represent the applicant?
Yes.
Sir, if you could just please come up to the microphone and give us your name and address.
Jeffrey Weisbrot, 28 Young Road.
Okay. And could you describe the apartment and the application before us?
Yeah, the apartment is situated within the dwelling. It's got a living room, bathroom, bedroom, and a small kitchen. And it's been in the house since the house was built.
Is anybody currently occupying the apartment?
No, there's no tenant.
Okay. And Tom, as the building inspector, have you made an inspection of the unit and it meets the current code requirements?
It meets the plan that was submitted. I don't know if the code changed, the entry is from within the principal dwelling, not separate from the exterior. That's noted on the.
Do you want to just give us 1 second? Should we just shift microphones down one? Yeah, we can do that. Okay. Oh, he's got 2 there. He's okay. Okay. I'm sorry, Tom, as far as for an interruption.
I was saying, I don't know if the code changed, the entrance to the accessory apartment is from within the principal dwelling.
Okay. And is there a second exit from the apartment?
To the outside, I did not observe.
There's 2 exits. One is the main door of the house, and the other one is the door down through the basement. And there's an access door in the basement as well. Should I say through the garage is more accurate.
So the egress from the house is the same as the egress from the apartment, because
Basically, the same door, but there's a second door. If that door is blocked, if the first main door is blocked, there's a door that leads through the garage to another door or through the garage doors itself. And there's a third door in the basement, a sliding glass door, 6-foot door as well.
Is this a 1-story house, 2-story house?
It's a ranch house, but we call it a raised ranch,
Right.
Because the accessory apartment is in the upper area by 2 stairs with doors that close it off from the main house.
Okay.
With its own bathroom, everything.
Right.
Okay.
Now, is there anybody residing in there at this present?
Oh, no, especially with COVID and what have you, we wouldn't even entertain that.
Yeah. On the checklist that the town provides for these accessory apartments, when was the principal accessory building constructed? You know when the house was constructed?
Yeah, it was mid-62.
Okay, so certainly before the 92 report.
Sure.
Okay. And this is the only accessory apartment on the property?
Correct.
So Tom, based on your comment, I'm assuming if this was a new request, it would need to have separate entrance, or,
That's the way I understand the code.
but since it's been there, it's okay.
Yeah, when was the permit pulled? Because that was a empty space, storage space above an existing garage when the house was constructed that received a permit for an accessory apartment thereafter to build that space out into what it is today.
You know, I understood it to be built with the house. The architectural plans show it as being there when it was built, and it's always been designated an accessory apartment. I've always had it as an accessory apartment since we moved in around 94, 95. I've come before the board at least a few times.
Right. I see documented approvals for 2003 and 2015 here, so.
Right.
Okay.
So this would be the third. Before that, there was no regulations to come before the board. So it's been there since I moved in, and it was there for the previous owner.
Have there been any complaints to the building department about the accessory apartment? Any issues?
No.
No. No one.
No. Very quiet.
Okay. Okay. Any further questions of the applicant at this time?
Okay, I do have a question, actually, informing you. Safely assuming based on the current codes that the town enforces with Westchester County for the septic, you do realize the septic has to be pumped out every 7 years.
Yes, and
No.
it was.
Arnie, it needs to be pumped out every 5 years. And every single application that we take in the building and zoning department, regardless of what it's for, has to have proof of septic cleaning within the last 5 years, or we won't entertain their application.
Okay, I just bring it to the general public who's watching, so this way it broadens the
Yep.
knowledge of the town to have their tank pumped out every 5 years. And
Yeah,
that's-
of course. That's a
I
good
stand
idea.
corrected,
Thank
it is
you.
5 years versus 7.
Yeah, 5 years.
Okay. Any further questions from the board? No. I'm going to open it up to the public. Does anybody here wish to speak in regard to this application? This is a public meeting which is online. Anybody who's watching at home, if you'd like to call in regard to this application, there are phone numbers on the screen. Simply have to put in the Zoom meeting ID number and you'll come right on. We'll leave it up for about a minute to see if anybody from the public wishes to speak in regard to this application. And sir, did you have any further comments in regard to the application?
Oh, no, but I did have the septic pump for this purpose.
Right.
Thank you.
Yep. No one coming on? Give another 30 seconds here. Okay, Paul, we have nobody? No, okay. Okay, so we're going to end public comment at this point in time. Any further last chance? Any questions from the board comments? No? No. All right. I'll take a motion as the type of action.
Type 2.
Second?
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye.
Thank-
I will take a motion as to whether we're going to grant or deny the 7-year special exception use permit.
I move we grant.
Second.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye.
Thank you.
Congratulations, sir.
Thank you.
Your application is granted.
Thank you very much.
See you in 7 years.
Yes.
As indicated, we're going to go to item 3 on the agenda. This is of UB Somers, Inc. This is an application for a height variance for a new business sign for AT&T in a neighborhood shopping district at 80 Route 6 Baldwin Place. And is there someone here to represent the applicant?
Yes, Joshua Cohen from Signorama in Millwood.
Okay. And how are you related to the applicant?
We are the sign company dealing with the signage for that location.
Okay, and you're authorized to speak on behalf of UB Somers Inc.?
Correct.
Okay. Could you briefly describe your request before the board?
Yeah, so originally, so this has been presented a few times to you guys in the past, and over the course of presenting it, there was an issue with the location of the AT&T verbiage versus the globe. So this most recent presentation of the sign, we have it at a 40-inch tall by 40-inch wide logo. And instead of having it stacked up on top of the letters, we're having it justified to the left of it. So
And this sign is currently on the building, correct?
no, so this is going to be this is going to be a whole new sign.
New sign.
Oh, so you're gonna take down, because there's an AT&T sign with a globe on the building now.
Correct. Yes.
We're gonna remove that.
Correct.
Can you tell me the size of the one that's there now?
The one that is there now, I know it is small. I don't have those measurements off the top of my head, unfortunately. I don't have the paperwork here.
Okay.
Tom,
Yeah.
I think I could lend some information here. AT&T was in that shopping center and they moved from one location to another location and they took their sign with them. That sign was fine for their previous location, but really not, it was kind of discombobulated for the new building. So immediately it was brought to my attention. They put up a sign. Do they have permission to have a sign there? No. It went through the ARB back and forth several times. There should be a letter of support in your packets from the zoning board, understanding the reason for the need for the height variance, and they would support that because it just makes it help me here, Josh. It's
Disproportionate. It's not,
Thank you.
it's
Yeah,
a little
it's-
too just sizing wise, scaling wise doesn't
And-
not appropriate.
And I will add that the original proposal was even bigger than it is now, a lot bigger. And the zoning board, they went back and forth. This application was on the zoning board for almost a year now.
Yeah.
I mean, the ARB, and they finally, agreed on what is presented to you this evening.
So as far as the look of the sign, it's gonna look just like the one that's up there now, but at these different sizings. Right?
Correct.
So in other words, the globe is to the left of the text.
Correct. Yep. And then it is centered within the entire store frontage, left to right. And then if looking at the drawings that you guys have, the store frontage is indicated by that red box on the bottom. They kind of go in on the left, where the doors are, the windows to the left, they go a little more than halfway through that window. So that's, center it within their store frontage. That's what we plan on doing with that.
So the diagram presented to us, or the photograph presented to us with the sign imposed on it, is a accurate representation of what you're requesting.
To scale, yes, correct.
Just, yeah, right. Okay. Okay. I would like to make mention that we do have a memo from the Architectural Review Board to the Zoning Board dated December 2nd, 2022. It's just a couple of sentences. I'll read it real quickly. At our December 1st, 2022 monthly meeting, the board met with Greg Thiel of Signorama and AT&T store manager Marco Litchfield to discuss a wall sign proposed for AT&T, which relocated within Somers Commons at 80 Route 6. Although the board did not object to the design and colors of the sign proposed, they couldn't approve it as the Globe logo is 16 inches higher than what is allowable as per the code of the town of Somers. The board does, however, understand the need for the height variance.
What's the allowed square footage, Tommy?
Half the frontage in width and 24 inches in height.
We built this.
I've been there a few times.
So they're well within their square footage.
Well, within their square footage, they're exceeding the height, but the height, the text, the AT&T text does meet the height requirement. It's just
Okay.
the globe. So, and if you look at the overall surface area of it, it's not really too excessive, I don't think. And
That looks small.
It was confusing because I presumed that the sign that was up, that's why I said, there's no way that sign looks too small that they have up there because that's not the actual, that's the old sign.
Yeah.
So it will be bigger than the one that's there. But it's also up higher off the ground than most signs in that shopping center. Most of the signs go in that space below. So given that it's up higher, I think that even makes it less, a slight, a variance over the size makes it less noticeable because it's pretty high up there.
The sign really doesn't seem extreme to me when I look at it on the photograph.
Right, I agree.
It looks small.
Yeah, I mean, it could be, given their frontage, I'm sure it could be at least 10 or 12 feet wide. If they have that much space. So to give them a little bit of length in that little section of the sign, I don't see a problem with that.
Right.
Particularly since it's such a tall portion right there.
Yeah.
Makes a lot of sense to me.
Okay. Any further questions of the applicant from the board at this time?
No.
Okay. Sir, do you have anything else to add at this point in time before I go to the public?
I think that'll do it.
Okay. Does anybody here wish to speak in regard to this application? Any comments, questions? And also, we're going to open it up to the general public online. Once again, any interested member of the public who wishes to call in regard to this application, please dial one of the numbers in the white box. Put in the meeting ID number, and you can come online and ask your question or have a comment. We'll just leave it open for about a minute. Paul, do we have anyone trying to come on? Nope. Okay. All right, final time for comments or questions. Anything further from the board? Nope. No. Sir, as the applicant, anything further that you'd like to say before we take a vote?
I think I'm good to go.
Okay. Okay, can we have a motion as to the type of action?
Make a motion type 2.
Second.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye.
Thank you.
Can we have a motion whether we're going to grant or deny the 16-inch height variance as requested by UB Somers Inc.?
I'll make a motion to grant the variance for 16, to grant a 16-inch height variance for the sign.
Second.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye.
Thank you.
Congratulations, sir. Your application is granted.
Much appreciated. Thank you.
Thank you. Have a good night.
You as well.
Thanks, Josh.
Thank you.
Don't know. We're going to find out though.
I'm just gonna hand a copy.
Yeah.
Or I have.
You have it, okay. Thanks.
Okay.
Yes, copies of what I emailed you all late this afternoon will be distributed at the appropriate time.
Actually, they have already been distributed.
Oh,
So-
okay.
Okay, so we're going to go to what's marked as item 2, but is the last item on the agenda this evening. This is the application of Victor and Deborah Wu. This is an application for a side yard area variance for an existing in-ground pool accessory in an R80 residential district at 8 Silver Springs Court, Katona. And sir, if you could give us your name and relationship to the applicant.
Sure. Good evening. Good evening, Chairman Canestra, members of the board. Michael Caruso of Cuddy and Fader, attorney for the applicants, both of whom are in the meeting room tonight. Good evening. So would you like me to run through the top?
Yes, if you could kind of give us a,
got it.
describe your application and please.
Of course. I know there's some collateral issues, so if the board would like, I'll just start with the requested relief and then entertain any questions. And then perhaps I can address the submission that was made 2.5 hours ago as well. Okay.
Sure.
So Chairman, Canistria, members of the board, thank you for reviewing our application tonight. This is an area variance application. We are seeking an 11-foot 6-inch side yard where 15 feet is required along the northerly boundary of the property, which is 8 Silver Springs Court, where my clients have their primary residence. The order that we are appealing from is an order dated October 25th, 2022 by the building inspector. And that order indicated that the swimming pool that existed in its current form on the property didn't conform to the 15-foot setback requirement for R80 zoning districts. And the determination denied a C of O application for a building permit number 2019:BP 274. So as of October 25th, 2022, that C of O application was denied. Within 60 days of that application being denied, on December 23rd, 2022, I've hand filed an application for this area variance, sat down with the building inspector on the day of, got the application stamped and submitted. The application you have in its current form before you was slightly amended. And there's some backstory to that relating to other issues, which we can get to. But the bottom line is the underlying application was within 60 days. The order that was appealed from had never been rendered, and that's why we're here. And the amendments to the application were not in substance, but just as to some events that had taken place since the filing of the application as they relate to the property itself. So as we indicated, this is a pool that encroached on that setback by a factor of 11 foot 6 inches. So we're seeking approximately a 77% area variance. And I'll run through the factors with you.
Sorry, can I just back up on one before you go into all that?
Sure.
Can we just get clarified? So there was an application submitted on December 23rd,
Correct. I have a copy of the stamped cover page if you'd like to see it.
and that was not heard. So that would have been heard by us at our January meeting if it were submitted? Denise, was there an application in January, December? I mean? Oh, she can hear me.
Yeah, I can hear you. I don't have that that agenda in front of me. Mike can tell you when he last met with the zoning board, but it didn't have anything to do with this application, correct, Mike?
So your application that you submitted on December 23rd was never heard?
Well, it
Correct.
was calendared for February. It was never heard. And we're here tonight on that application
Yes.
It was calendared for February.
in
But-
December. Yes.
Okay,
I'm not sure why scheduling wise it was calendared
did-
for February.
okay.
It was, Mike gave me that application December 23rd, and the deadline date for the January application had come and gone. So he
Got
was told at that point it would be on February 21st. And that is this application. This is not when they were previous before you.
Understood. Okay, thank you.
No, it's good clarification. Thank
Yep.
you. So just for the viewers at home, the document I have in front of me is just a stamped cover page of my first application, December 23rd, with the Town of Somers Building Department stamp, because I sat with Tom and we went through it together, discussed the application. And that's why we're here tonight. So we amended it, and I'll get to that as well. So on the points that we need to lay out for this board on the practical hardship test, as indicated, the pool encroaches on this setback. It's a pretty unusual path to how we got here. Again, we can get into that as well. But the basic facts in the application are that we have a pool that has now been conformed such that it doesn't encroach onto neighboring property. There isn't a wire, a pipe, or anything that encroaches onto this property next door to us, which is, why we amended our application to show the engineering and all the inspections that happened between and during the course of the first submission and our amended submission in February. So we have some engineering to support that as well. But so as to number one on the undesirability potential for changes to the neighborhood, my clients have advised me, and I've seen with my own two eyes, that there are swimming pools that are in proximity to boundary lines in the neighborhood. There are fences. This isn't out of character. It wouldn't cause an adverse aesthetic or environmental impact in this instance. We've mitigated any environmental impacts. There's no drainage issue. There's nothing relating to this use that would generate anything adverse in those respects. We'd submit that while it is a 77% variance, and there's certainly case law that says in certain instances, while that may be substantial, we believe in this case it's not substantial. Based on the orientation of the property, the masonry work that was done, the way it's set into the property, and certainly by the boundary and the view shed, we don't think this is a substantial variance for those reasons. There really, on the fourth factor, there really is no feasible way to mitigate the harm and the need for a variance here. As you probably are all aware, when the pool was initially installed, it was pursuant to a survey that was drawn with setbacks on it by a prior surveyor. The licensed pool company, which was Nijam & Sons in Danbury, which has a great reputation, drew their pool rendering and put the actual pool located on the property, submitted that to the town, was reviewed and inspected. The thing was built in the current position it was in, and some of the patio and some of the structures, including the fence, happened to be over the line, which nobody anticipated, unfortunately. And it was only because the neighbors got a lot line survey later that revealed that it was built over the line, obviously unintentionally. So as to whether it could be mitigated at this point without extremely great cost and difficulty to the clients, something they couldn't have foreseen, there really is no way to mitigate this other than an area variance. And as to the self-created nature, we respectfully submit to the board that we used a reputable pool contractor. It was inspected by the town. My clients went through every available professional channel they could to make sure this was done right the first time. It was a very unusual scenario that this was surveyed incorrectly and ended up across the line. But that has been rectified in large part because, as you'll see from the photos we'll go through in a second, the patio and the pool has been or is now on the property, on my client's property. So if you were to look at the link survey, which is attached, which follows the October 25th determination, you'll see that Link has shown the pool obviously in its position where it was, and there is a retaining wall immediately to the north of it, which is on the Wu property, and no part of that retaining wall is approaching. As I indicated, there are no gas lines, there's no electric services, no drain pipes, there's nothing that we have on their property. That was inspected by the town several times, and in the fall and into the winter. So we've had the thing opened up. Tom's been to the site many times. I believe, Tom, correct me if I'm wrong, the town engineer has been to the site as well. Is that correct? Okay. I thought that had happened, but there have been numerous visits, and I can represent to the board based on the next drawing prepared by Joel Greenberg, which is a detail of the retaining wall. Joel is certifying, and it's obviously true, that there is nothing above or below grade on this wall that is on the neighbor's property. Not even, nothing. Sprinkler hoses, gas lines, fabric, nothing. So that's why I have Joel's survey. Behind that, you're going to see a drawing prepared by Nijam & Sons dated September 4th of 2019. And this is the drawing that shows the prior state of the pool and the retaining wall in locations that were actually encroaching on the neighbor's property, obviously unintentionally. And those conditions have been rectified such as they are not on the property any longer, on the neighboring property. And my clients, this plan was generated from an older survey that is on file, I believe, with the town, which had the incorrect measurements of the setbacks to certain drainage equipment that was installed, I think, in 2008. So if you will flip once more, the next series of photographs, and I apologize, they're in black and white. The resolution is not the greatest. The first photo you'll see is down the fence line, and you'll see some gravel and some large rocks, and you'll see a rounded patio. That is looking down the line of the boundary at what the pool used to look like and what the patio used to look like. And I have a color photo of that. If you'd like to have that as well, I can just pass that around. Does that help? We have color? Okay, good.
We have color.
The next photos you'll see there should be a photo of the corrected version, which are the last two documents in our packet. So you'll see the photos I have here that I'm holding up. The wall, this is the north where my finger is right here. This has all been brought in. Everything you see where my finger is gesticulating here is on the Wu property, including the fence posts. I believe those are the new fence posts, and the temporary fence, which is now a permanent fence. That is all on our property. So we took great pains, and my clients have undertaken a lot of work to make sure that that was corrected promptly. And it was done so in a tasteful and nice looking way. So we've brought the pool and the patio, if you will, that one structure into compliance and off of the other property. The fencing that was previously on the neighbor's property is removed. That fencing is now fully compliant. So that is, in a nutshell, how we got to the board today, and that's what we've been through. It's been an intensive process, a lot of work on the site. As you probably know already, there were 2 pending code violations that have been resolved before this application was filed. So I appeared on behalf of the Wus. Those issues are no more. There is no longer a side yard or a fence violation. And those are subject to the Wus conforming the property and removing the encroachments, which they have largely done. By largely, I mean probably more than 90% complete. And they have a certain amount of time to do that. But that is a difference between where we were when the Wus prior attorney brought this application and where we are now. So that's in a nutshell where we are, and I'm happy to provide any further information that the board would like.
I have a question. Based on the picture that you showed us last, the new stone wall with the temporary fencing with the white post, I see a bunch of white posts further out. Was that where the existing fence was? And if so, what procedure you're going to do to remove those posts from the ground?
I have some better photos I brought for tonight's meeting as well, which will show you, I think, a little bit clearer what is there now. I think those posts may not be there anymore, and I think they might have been the posts that are here.
If I'm looking at, seeing what I'm seeing.
Can I give you to you? Okay.
Because there are posts behind. I'm referring to is these white posts back in here.
Looks like the stubs of the posts.
Right, stubs.
Yes, sir. I think I would have to ask my client specifically, and I have to ask him if that. Based on the photos alone, I can't tell you with specificity where those posts were placed. Yes, please.
It's most likely, I would assume that those posts were set in concrete.
Right.
So that.
And there are reports that there are.
All right, so this is Victor Wu. So Victor, if you could tell the board where these posts were set in the photograph and where they are now, we'd appreciate it.
No, you're talking about this. Are you talking about these? I don't understand which posts you're talking about.
The small little tiny posts that are in the background.
In the back.
I
These?
think he's talking about it here.
Oh,
over here.
I think he's talking
about these.
right here.
Yeah.
So
Yeah, we see the stubs of the, it looks like the old fence line
Yeah.
still in the ground. I don't know if that's been resolved. or not.
I was looking at the wrong.
Okay, hold on. Sir, you'll have a moment. You'll have your opportunity to speak.
I apologize. I was looking at the wrong spot of the photograph.
Okay.
Those were installed on a location that was on the neighbor's property. The neighbors since took it upon themselves to cut those posts and rip my client's fence down. Obviously, we weren't given a choice in that matter, but that is where the old fence was located. Sorry, I didn't know where you were.
To the best of your knowledge, are those posts and concrete still there? Because if you have not removed them.
Did you have them chipped out and removed?
They are still there because we have not been allowed on their property to remove them.
Okay. I just want to know what the status is. Just to be clear, everything else though, there's no further encroachments at all.
Correct.
On the property. I do see here back in October, I guess it was Justice Timone stipulated, removing all the items from the property. Why did Justice Timone get involved in this?
Okay, so when this matter was originally brought to the board, there were threatened and or pending code violations. I believe they were active code violation cases. So the Judge Timone had had these down for fence violations and encroaching into the neighboring property on the wall. Why did this stipulation come to be? That's what you're asking?
Yes.
Well, the judge wanted to see that we had a plan to remove the encroachments, and removing the encroachments was part of the bigger picture as to why we're here tonight, of course. But if we remove those alleged violations, then we would be offered a disposition in that court with a time frame to cure them. And the time frame, obviously, we have quite a bit of time left on it, approximately 5 months to do the rest of the work. But to get onto the neighboring property, we do need permission from the neighbors. We can't just go on and do this. But if the neighbors don't give consent, there is a proceeding that we can avail ourselves of in Supreme Court Westchester to get that temporary license. So my clients have done everything they can on their property to cure without encroaching and going on to the neighboring property so much to cure anything that's over the line, so to speak.
The setback, is it from the pool itself or is it from the patio?
I think it's from the pool itself.
Okay.
The swimming pool itself.
Let me just be clear on that as well. Bear with me 1 second. Sorry, I shuffled things around a little bit here. Bear with me 1 second. I believe it's from the pool itself.
That's what the
Yeah.
building inspector has confirmed.
I just want to make sure of that because there was a little bit of confusion expressed in some emails back and forth, not by the building inspector, actually by me initially, but
So the current fence is right on the property line. We're very close.
it's right on, it's not over. So it's not presenting an encroachment. Absolutely nothing is over the line. So that's one of the material changes in the past year that have taken place, in addition to, cutting the deck and really moving everything closer on the pool side.
Can you give me some information as to discussions or conversations that you and the property owner have had with the neighbor to try to resolve this issue?
Sure.
I mean,
Of course. Yeah, obviously that was an early discussion point, and I see Whitney Singleton's on the monitor as well, so he can speak to that if he likes. But the proposals that were exchanged, and this, some of it does date back a little prior to my involvement, but ostensibly the same issues have been discussed. Number one was, can the Woos purchase a portion of the property where their structures were encroaching on and request a lot line adjustment from the town? That discussion took place. Unfortunately, the price tag for that transaction was far too high than my clients could justify.
I may amend that before that point.
sir, come to the microphone just so we can hear you.
Before it came to that point, we had discussed that, or at least I had brought that up. And our neighbors rejected that in principle. Didn't even entertain a dollar amount. In fact, his exact response to me was, "I don't want your money." So we had several talks. I have sat in his backyard table. I've sat in his living room and we've talked. We've telephoned, we've texted, and of course our lawyers have communicated. There was rejection or no desire at all to purchase or an easement or any of that nature. I had entertained thoughts to try and alter it, hoping to not have to cut the pool, patio, and the existing stone, that I could move the fence as far back as possible. That was rejected. That I offered to put plantings in the space vacated by that if they objected to the fence being white in color, and that was rejected. His exact words were, "I want a clean property line." So there was never any further discussion before Mr. Caruso even came on board. We had already been through that, and it was rejected out of principle. And we've had even further talks once attorneys did get involved. And my main comment is to say that at no point did it seem like they wanted to try and find a mutually livable solution. It was from the very beginning, these are the demands. And it was nothing negotiable. Even when I started to capitulate to various demands, that I would move things or that I would help pay for this. When I said I'd move something, they asked for more. I said I'd move it, then they asked lawyer fees. My response, send me invoices. When I said that, then they said they wanted survey fees. I said, send me invoices. Then they talked about drainage issues. Hurricane Ida, I believe, caused flooding in their basement. And I got water in my basement too, but apparently that is the fault of the pool in their judgment. I disagree. I had to get a topographical survey to disprove this. Point I'm trying to make is that at no point did they try and meet me in the middle for anything. It was demands. When I capitulated, I guess they took that as a sign of weakness. They added demands on top of that. When I resisted, they added demands on top of that. I can give you a list of the demands. You have in writing what the demands are. They're extensive. I could have pursued an adverse variance attempt to try and solve this, which would not have been an easy task, I admit. But I just rejected that. I didn't want to do that. Because even if I were to win an adverse possession, what do I gain? I gain a few feet of dirt and rock.
You can't.
Taken from my neighbor. I didn't want to do that. What I wanted was a mutually agreeable and livable solution because we are neighbors. We share a common border. I'm afraid that never happened. It was a list of demands that never attempted to meet me in the middle. And just to kind of go into it, yes, they tore down the fence, even though it was still an issue in the court. They took it upon themselves to tear it down. But all I can say is, as a result, now there is nothing of mine that is on their property. And therefore, we are here for this variance. That is therefore the next solution that I need to obtain. So that's what I'm asking for.
I do have a question.
Mhm.
Regarding the survey that you had originally when you purchased the house. And when they had the property surveyed to find out there was a problem with the surveys. Was there any multiple surveys to see which one was right, which one was wrong on the surveys?
Oh, sure.
Yeah, so what you're referring to is, yes, there was a survey done long ago when there was a Coltech and a drainage system that was installed subgrade. I'm holding that survey here. It was from 2008, I believe, 2007, sorry. And it does have measurements off the property line, and those are off of which the pool contractor based his drawing, and that's how the pool got placed in the wrong position. Following that, I believe what you're asking is, have there been lot line surveys to find out who was right, who was wrong, or how this happened?
Correct.
The neighbors did commission a survey. Then my clients commissioned a lot line survey as well that located the problem. And that's how it arose. So
you're not disputing the survey provided by the neighbor?
no, we're not. No, we're not.
Everybody's in
Okay.
agreement with the survey.
Correct, Mr. Chairman. Yeah, we're trying to do the best we can here. We feel, and I think my client has availed himself of every reasonable alternative. And I've been privy to some of the negotiations where, to call a spade, the goalposts have been changed and shifted. I think Dan Toto, who was here before me, could attest to that as well. has not been an easy negotiation. So with that said, we really wanted to come to the board as a last resort, but we feel this is an attainable variance. We feel that we've done absolutely everything we can to make a difficult situation palatable and to give you an application we think that you can rule favorably on. And in this case, yes, there are factors outside that have colored the view of this matter entirely, but we think overall this is otherwise a simple matter to adjudicate. If the board has any, sorry about that. If the board has no other questions about the nature of the application, I could speak to the letter that was filed 2 hours before this meeting as well.
Okay, if you'd like to comment in regard to that, and then we'll go to the neighbor.
Well, it might be a segue that makes sense. That's the reason why I ask, is I can address some threshold issues. So it's come to my attention through Mr. Singleton's office that the neighbors don't feel that we have a timely application. And let me speak decisively to that point. Again, this application was initially filed in December 23rd, within 60 days of Tom's decision on October 25th, which was a new decision, a decision that had never been rendered before by the building department. So that's well within 60 days, which is their first point, which is just flat wrong. The decision itself and the appeal was filed with the building inspector, who is the administrative officer charged with enforcing the code. It bears his stamp. I sat with him on that day, and for about an hour, we discussed the application. So that's the second point Mr. Singleton raises. As to restarting the clock on page 3 of his letter, there is no restarting the clock here. We've never brought this application. Dan Toda, who previously represented the Woos, was here before this board. He withdrew their application under totally different circumstances without prejudice, which means we had the ability to bring that same application if it were timely. But this, again, is a different application. It relates to a different order. And the order was, we're denying your C of O for the pool on October 25th. So this isn't a repeated application. We're not just putting a different date on it and throwing it at the board. It's a totally different application that has never been adjudicated. And finally, you'll notice on page 4, Mr. Singleton talks about a doctrine known as res judicata. And I can speak to that extensively, but I'll try to be brief. Res judicata, folks, means that if this board has actually litigated and necessarily decided an issue or series of issues, that my clients cannot come back to you and ask the same transactional question again, which is the same set of issues. This board has never decided, because we withdrew the first application and because we've never appealed Mr. Tuma's October 25th decision, this board has never heard that application. It's here for the first time. Res judicata does exist. People abuse it and try to bring successive applications. We're not doing that. It's very obvious. And I think it's an easy way to distract the focus. And I would just, again, drive home to the board that these are simple questions with simple answers. And that's my client's position with respect to Mr. Singleton's letter. And I thank the board for giving me the opportunity to speak about it.
Okay, thank you. I think I'd like to hear from the neighbor at this point in time. I believe, Mr. Singleton, you're going to speak in regard to the neighbor.
Yes, I am. Well, let's start. I'm just trying to figure out where to start from, given the misrepresentations that were just put before you. I can speak procedurally or I can speak substantively. Procedurally, your board is without authority to entertain this application. It is not a simple matter as laid out by the applicant's attorney. It is straight out law. You cannot hear it. It's very clear in numerous court cases, including the highest court of this state, that you cannot restart a clock for the same underlying relief by simply filing another application with another title. The relief that the applicant is seeking tonight is a determination from the building inspector that the swimming pool does not conform to the required 15-foot setback. The denial letter a year and a half ago, was that the swimming pool does not meet the required 15-foot setback. It is identical relief that they are seeking. They can put window dressing on as to where they move the fence and everything else. But as Mr. Tuma and the applicant's attorney has stated, those are not things from which a setback runs. It is absolutely ludicrous to me that your board would consider an identical application for identical relief after applying for a certificate of occupancy, which they were already told is not permitted under the zoning, and they were already denied that by your board. He can say that they withdrew without prejudice. There is no such thing. When you're time barred on day one, you can't withdraw your application and then resubmit it and all of a sudden be timely. Your board unanimously determined at your June 2022 meeting that you were without authority and that the application was not properly before you. Nothing has changed. So procedurally, your board may not hear this application. And if it does, you run I don't even want to say substantial risk. You will be overturned on appeal. And I certainly encourage you to verify this with whatever counsel your board chooses, because this is not permitted by your board out now. If you want to go now to the substance of the application, I'm happy to. With regard to the application itself, I specifically asked the town, were there any submissions other than the application that we photocopied from the town? Were there any submissions since Mr. Tuma's October 25th, 2022 memorandum? I was told no. I was asked why things weren't date stamped, and I was told that the zoning board does not date stamp any material. I'm going to give Denise an opportunity to speak, because I can put my email up on the screen, Denise.
But I did not say the zoning board, Whitney. I said me. I said on behalf of the zoning department, I do not date stamp my stuff in. That's what I
fine.
said.
If I
Me.
misstated that, I apologize.
Yes, it was me, not them.
Okay, all right. But I did ask if there were any other submissions, and you said no.
None that I was aware of.
Okay, so, and the application that is posted, the application that we photocopied was notarized and signed on January 31st. So how you deem it to be timely, I have no idea. This is the first time that we are hearing that an application was submitted. I don't even know if your board has a December application. Does your board have a December application?
I will let Mr. Caruso speak about that.
Well, Mr. Caruso doesn't. I'm asking the board if they have it.
I mean, I think the applicant already stated that we has a time-stamped cover from the building department. And so I don't think we should spend our time talking about whether it was 60 days or whether or not the building inspector received it. You have other very valid points, but I mean, he's here testifying as an officer of the court that was submitted at that time.
I'm sorry for interrupting. What I'm saying is we have not seen that application. Do you have that application? Do you have the December application?
We have somebody testifying in front of us with a copy of it.
We have that application on our agenda this evening. So
the December 23rd application? Or the
application, which was timestamped on December 23rd. It's not a December 23rd application.
Okay, because it wasn't part of what was provided to us, and we both went to the building department and requested copies.
And that explains your letter, but it doesn't explain why you're still arguing that point.
Well, the point is it's highly irregular, but nevertheless, you're absolutely right. If it was timely filed, that's fine. I just find it odd that the application, not the cover letter, that the application was dated and notarized on January 31st.
what?
Yet
So
it was
we have-
submitted in December.
We have a building inspector who received the application and an applicant who filed it. So I don't think we need any more on that in terms of
Okay.
time.
All right. Nevertheless, with regard to the application before you, it is nothing more than a regurgitation of the original application. It seeks the same relief.
It proposes the same setbacks, and there is nothing new with this application to constitute a material difference so as for your board to be able to entertain it. They were in violation before, they're in violation now, and your board cannot hear the application. And I strongly encourage you to get advice of counsel before making a determination. With regard to the substance of the application, I will state this. What was stated by the applicant and its counsel was complete horse crap. That is not what has transpired here. The Woos knew where the pool was. They knew where the wall was. Look at the survey that shows the hub and tack being cited by Insight Engineering. They did that in anticipation of the pool being done. The hub and tack stakes were put in 2019, right before they undertook the pool application. It shows where the 15-foot setback was or is. There was never any attempt to follow that. As a matter of fact, all of those stakes, which are 2-inch by 2-inch wood stakes with nails inside of them, placed several feet all along the property line, were ripped out so that this pool could be put in. They knew exactly what they were doing, and they have severely misrepresented how things transpired in this case. The original attorney that represented the Woos encouraged them to remove all the encroachments and to resolve this issue, and they did, and they chose not to. They hired another counsel who pleaded with me to participate in a lot line change, or in the alternative, a boundary line agreement, which my clients, as Michael pointed out, originally were not in favor of. They want the property line maintained, and they want it respected with everything meeting setbacks. So that originally didn't go anywhere. After a lot of pleading by them for both a lot line change and or an easement, we ultimately agreed. All we asked was that if they wanted to buy the property, pay for it. If they wanted an easement, my clients didn't want any of their money. They just wanted their legal surveying and damages covered. I drafted an agreement at their request. I'm happy to provide it. I'm happy to put it up on the screen for your board to read. All it requested, and all the meantime, while this was going on, the Woos were submitting an application which they promised us they wouldn't submit. And seeking a certificate of occupancy for what was already determined to be an illegal use. So all the Woos, all the Stance Use ever asked of these people was to pay their legal fees, their survey fees, the damage to their sprinkler system, which the Woos ripped out of the ground, and the damage to their trees, which have fallen over as a result of the redirected drainage, and damage to the shared drainage system, which still does not work.
Counselor?
Yes.
If I may, it's really not our job to judge the equities of the negotiation and.
No, but.
And
Sorry.
You know, you made a very valid point of whether or not this is the same application. And I kind of want to ask,
Sure.
Doesn't the building inspector make that first determination? And if he finds it to be the same application, doesn't he have the right to reject it at that point in time?
The building inspector receives an application, he has to act on it. He rejected it the second time for the very first time, for the same reason he rejected it for the first time. It is nothing more than a regurgitation in the form of a request for a CO.
No. So he rejected it not because it was the same application, though. That's my question. So I think he has that ability to reject an application if it's the same one. And what you're saying is we can't review it because it's the same application.
Correct.
But we're reviewing based on his denial letter, and his denial letter doesn't bring that in. If I'm correct.
So if somebody applies for a building permit that's rejected, and they don't timely appeal that building permit denial, all they need to do is build that illegal structure and then apply for a certificate of occupancy and somehow the clock restarts? That's exactly what the Court of Appeals said you can't do. You can't, under the guise of something else, ask for the same relief. The underlying relief here is a variance setback from the 15-foot side yard setback. They've just it's a pig dressed in different clothing.
I gotta
Okay, well, let's
No,
wait.
Michael, you had an opportunity here.
Let's
and
have
quite
Mr.
Quite
Singleton.
frankly,
reply.
with regard to the issue of the negotiations between the parties, I do believe that they're relevant, because the Woos have represented to you that this would cost hundreds of thousands of dollars to relocate this pool. We stated, we gave them what our surveyor fees, we had 2 separate survey fees. We gave them our legal fees. We gave them an estimate from their contractor as to what it would cost to replace the trees. And we gave them an estimate from their contractor as to what it would cost to replace the sprinkler system. It came to $27,000. We asked for that. After they asked us to draft a stipulation settling this matter, they turned around while they were making applications to the town, which they promised they wouldn't do. They turned around and called our request extortion. All right. I don't, this is one of the most egregious cases I have ever seen in a zoning context between neighbors. Mr. Wu stated that they share a common boundary line. That would be nice if they did. The fact of the matter is they deliberately went over that boundary line and built walls. They built encroachments. And when we asked them to get off, they continued to do work. The building inspector told them not to do any work on the property until there was a mutually acceptable plan, and they continued to do work. Yet their counsel would suggest that he's going to go to court so that he can get an order from the Supreme Court so that they can go onto the property and finish ameliorating the situation. This is a gross misrepresentation of what has happened here. And the Woos should not be rewarded for doing something in express violation. And they had a survey done with markers put in place. And it is a complete farce to suggest that this was done in error. Nothing the Woos do is done in error.
Yeah, Mr. Singleton, one of the things it sounds like is that your client to resolve the issue would be willing to take basically a reimbursement of costs related to this matter. And it almost seemed as if the applicant was willing to offer that. I mean, have the two of you discussed this and come to a,
Yeah.
I mean, let me talk to Whitney first and I'll go to you.
I'd be happy to show you our course of emails where at the request of the Woos, I drafted a stipulation that set forth exactly what their damages were, what they would do with regard to this application, and why it would change the nature of the application material so that it could appear before your board, and what those expenses were. I sent it to the applicant's counsel. I didn't hear. A month went by. I asked again, what's going on? I haven't heard. Next thing I know, he writes back to me saying, the Woos will not agree to this extortion. And I said, okay, Michael, the next stop is for me to begin opposing an application that I understand that you just put in. I'm going to begin working on that next week. Please verify that the Woos are not interested in this because my client's damages are only escalating. I've been through 3 separate attorneys on this matter, and it's been going on for 2.5 years. And to stroll in and suggest that this is a new application simply because it's an application for a certificate of occupancy as opposed to in response to a notice of violation, it is absurd. It's lipstick on a pig. It is the same identical relief, and your board's prohibited from entertaining it. And it's unfortunate because, as you can see, all along, the stance use have been nothing but accommodating. But what did the Woos do? The Woos erected a fence on their property and then put a lock on it so the stance use couldn't even go on their own property. I mean, I have never heard of something more egregious in my 30 years of practicing a law before zoning boards, and then to see it presented by the Woos and their counsel as, oh, this is very straightforward, no big deal. This is a very egregious thing. And it's insulting that my clients have been willing to cooperate in a number of fashions, which have been rebuffed a number of times and been misled while the woos have been secretly making applications. Michael points out the fact that he only got my correspondence a couple of hours ago. Well, I only submitted it to the town a couple of hours ago because they didn't have the decency to provide me copies that they had submitted to the town. We had an agreement that until there was a resolution and a settlement between the parties, that no applications would be submitted.
That's not true. I'm sorry.
Okay.
I can't.
Well, with your prior counsel, I certainly did.
I'm sorry.
Okay. All right. Well, sir, let me ask you this. And I don't mean to negotiate a settlement here, but if they seem to be offering that they want the expenses and your client said, well, I offered them the expenses. I mean, are we close to a resolution on this? Is this just a?
I can give you their agreement that Whitney sent to me if you like to read it. There's no backup for it. I don't know what they're substantiating this with. Maybe several years ago, this might have been an option before we came down this road and had, however, Mr. Singleton categorizes our exchanges. I litigate for a living. I've been before this board. I negotiate every day. When I'm not negotiating with someone who's negotiating in good faith, it's pretty obvious very quickly. And that's why these negotiations never advanced. These people who I don't represent cannot be satisfied. It's that simple. And I know I keep using that phrase, but
I actually don't think that even if there were a settlement or there weren't a settlement, there's still a matter of a variance that's going to be needed with or without a settlement. So I don't think we need to hear the debate over settlements. I don't think it's.
No.
Actually, that's not true. If they do a lot line change, no variance is needed. And that's one of the things that your board needs to consider as part of the application.
Right. But the lot line change came at the cost of $100,000, which my clients were just not able to pay. I'm sorry. That's just not reasonable. We couldn't do that.
To be clear though, Michael, that would have been a drop in the bucket for your clients, because what we had proposed was to give them a substantial area of land so that the very beautiful retaining wall that existed could remain in place.
Mr. Singleton, what relief are your clients asking for at this point in time? I mean, what are they looking for?
I am asking your board to refuse to entertain this application as untimely as the law requires.
Okay, thank you.
But what do you want?
No, hold.
Settlement.
We're talking about settlement.
Frankly, it's inappropriate because it's not our job to settle the matter. We have an application in front of us. And we have opposition to that application. And if Mr. Caruso, if you could speak briefly to whether or not this is the same application. Because the first two parts of this, I think there was some misinformation, and that's the third part of the opposition.
I would be more than happy to. So let me dispel the notion that we didn't file an application on the 23rd, because I specifically remember, and I will check my billing records and the mileage of my car to verify that I came to this building in a very severe weather event to file this application. I sat with Tom Tuma. He stamped this application, the cover page that I am holding here, that is December 23rd. So unless I'm living in an alternate reality, that was filed and done, and I prepared it. Period. The end. As to the issue of whether Mr. Singleton knew about it or not, I'm not going to disparage anyone in this room. I received an email from him that day, and I am happy to provide it to the board. Out of nowhere, he comes back asking, what's the status of negotiations between our clients? So fortuitous timing, but let's leave that aside. So as to the identity or the lack of identity, Mr. Lansky, between the applications, let me read from the board, from the building department's letters. September 3rd, 2021. And again, I'm happy to give these to the board. Mr. Tuma writes to the Woos, as per a visit on September 2, 2021, and a survey provided by the owners of the neighboring property for Silver Springs Court, it appears that your swimming pool barrier is located on your neighbor's property. In addition, the survey also indicated that your swimming pool doesn't meet the required 15-foot side yard setback. As you have been dealing with Denise Skirmer in the zoning department, both of these discrepancies further the need for a survey to be done. Following that, October 13th, 2021, and a letter from Mr. Tuma, notice of violation. Dear Mr. and Mrs. Wu, please be advised that a violation of Chapter 170A zoning schedule Part 1 of the code exists as your swimming pool does not meet the 15-foot required setback. In addition, your required swimming pool barrier is not located within your property boundaries. Please address the preceding issues that pertain within 30 days of receipt of this notice in an effort to avoid further legal action. The legal
What's the date on it? Can you just give me the date on that one again?
That's 10/13/2021. The legal action that followed was a code violation prosecution. And I don't recall the timing between this and that code violation prosecution, but we could not bring an area variance application with a pending code violation. So there is nothing to appeal here with an outstanding code violation action. The first letter isn't an order or a decision. It says, this doesn't look good, go get a survey. The second letter says notice of violation compliance order. Clear as day. I'm not disputing that. But the fact is, the Justice Court started enforcing that violation. I got involved in that process. We settled that violation with a stipulation. I can provide it to the board. It said fix these encroachments within a fixed period of time, which we are doing. And then I asked for the building department to issue a decision on the pending application for a C of O. I pushed for that. I actually filed litigation in Supreme Westchester for that. The building inspector then wrote the denial 10/25 of 2022. That is the issue we have appealed. Yes, it does indicate we need we violate a side yard setback. That hasn't changed. But the order that's being appealed from, or the decision being appealed from, is absolutely different. And that's what your code says. Any order of any officer charged with enforcing the code can be appealed to this board within 60 days. That's what we did. I don't know
May I
why.
address that?
Yes, Mr. Singleton, please.
Okay, first of all, his statement of laws is absolutely incorrect. He said that because he was answering a zoning code violation, that he could not go to the zoning board for an appeal to seek a variance. That's exactly what state law provides for. There's an automatic stay of all proceedings while you appeal a decision to the zoning board of appeals under 282 of the town law. They had the ability to go to the zoning board and seek a variance. That's what they did. That's precisely what they did. And now Michael is mischaracterizing what the history of this application is. They appealed the decision. They went to the zoning board. They filed an untimely application and they were barred from pursuing it. Your board made that determination. It was unequivocal. So your board made a determination that they cannot get a variance from the 15-foot setback because they were untimely. The fact that they're coming back now for a certificate of occupancy, for the same exact relief does not restart the clock. And there's 20, 30, 40 cases on this matter. All the way with very, very clear determinations from the Court of Appeals. I mean, the mere repetitions in words or substance of a prior determination should not be treated as a newly appealable order, requirement, or decision or determination. The fact that they are calling it a certificate of occupancy application does not change the fact that it's a variance, an area variance from the 15-foot side yard. It is the identical location, identical relief. The courts are not swayed by the fact that it's a application for a certificate of occupancy, an application for a building permit, an application in response to a notice of violation. That you simply cannot relabel your application and ask for the same relief. The courts will not countenance that.
But Mr. Counselor,
Yeah.
if I may, because I'm looking at the opinion that you quote, and there seems to be a difference there. They're saying that the building inspector's letter in that case just acknowledged his previous determination.
That's Palm.
Yeah, that's
Yeah.
Palm. And so what what you're talking about is a different situation here, because we got a different letter from the building department. And so, I understand the argument you're making, but the building inspector didn't look at this as the same application, and he didn't acknowledge it as his previous determinations in the letter we got from him.
Didn't he deny it for the same exact reason that he issued a notice of violation? That it doesn't meet the 15-foot setback.
But that's not the same
exactly what he
application.
did.
So
That is precisely what he did.
So there does seem to be a difference here. I understand your point that you're saying that the underlying event is the 15-foot setback for the
That's
pool.
right.
But
And the underlying application was for a variance.
so the question of whether or not an application for a CO is different from an application for which related to code violations, which have been fixed, is what
No, they haven't been fixed.
Don't-
And discussing the justice court in this matter is just a red herring. Just
But don't
like
we have-
hold on.
Don't we have to differentiate between, there was never an appeal, as I understand it, there was never an appeal of the building inspector's determination.
That's correct.
No one has ever disputed that they were in violation of the setback. Okay. So in June of last year, when we heard, when there was an application, it was an application for a variance.
Mhm.
It was not an appeal of the building inspector's determination.
Yes,
We
it
all
was.
agree.
All applications are appeals of the building inspector's determination.
Request for
That's
variance.
what the law provides
An
for.
appeal of a determination.
I guess it would be. Yeah, I mean,
Folks, the bottom line is that we have two parties that are unhappy with one another, and they're $27,000 apart.
but we're not going to solve that. That's not
Well,
our- that's not our job.
why are you sure they don't want to settle?
We
I mean, come on. So,
it's clearly
yeah,
I would love to be able to do that, but unfortunately, we're
Well,
far past that.
are apart
So-
because both sides chose a lawyer. So now we have two lawyers, so they're doing their thing. I wonder, is it makes sense?
I have to protect my property.
Sir.
Just take a look.
Sir,
Yeah.
We're clouding the entire mess with a lot of legal mumbo jumbo.
Sir, if you want to speak, in regard to this application, I'll have you come up and speak at the microphone, but just,
I'm sorry.
no, but if you want to, you can go up and speak. But please, don't, people at home can't hear you. You're not on microphone.
My property, so
Sir.
what?
Panta, if you wish to speak, go to the microphone.
I'm sorry. Okay, I'm done.
To drive this home a little bit, the issue that may be confusing here is that the relief may follow an application, but the relief being sought in different instances doesn't beget the same application. And your code does support what I indicated before. Again, let me just get back to level ground for a minute here on the issue of whether we have whether we had the opportunity before, let's say on prior submissions. And I agree with the gentleman on the second to the left on the board. Forgive me, I can't call your name up, but this board hasn't adjudicated or decided anything. The building inspector did not reject a prior application. Whether we sought the same relief in both applications is not the guidepost. It is what's the nature of the application underlying it. So when I was advising the board that an application to this board can't be made with a pending violation, there's support in your code. And in chapter 67, application processing restrictions, 67-4C says, in the event that an application is in process before any of the boards or officials listed above and a violation occurs, processing the application shall cease upon presentation of proof of the violation by the ZEO. Once the applicant submits proof the violation of the chapter has been corrected, the application process can continue. Now, we're not continuing an old application. I'm simply providing support for why the application was discontinued previously. And again, the board never decided it. Regardless of whether we sought the same thing, it was never decided. And
That's an
leaving,
incorrect statement, Michael. You weren't there.
please don't interrupt me. The only thing that I want to leave the board with at this time, before we completely confuse the issues, is that in terms of resetting the clock, whether we're here properly or not, I think Mr. Lansky offered some great questions. There are plenty of cases, and I'm holding them in my hand, that have litigated the issue of timing and whether you bring the same application. As Mr. Lansky indicated in the Palms case that Mr. Singleton cited, the issue with the Palm restaurant in East Hampton was that they had an old C of O. The building department issued them a new CO when they refinanced. Issuing the new CO, which didn't change a thing, did not reset the clock. We're not doing that here 20 years later. There are plenty of cases, including 2 that I'm holding, that indicate, regardless of whether, for example, let's say you heard this application. Let's say this is the identical application, for example. Nothing has changed for a moment. There are cases that say where there's a material change in circumstances from the first application to the new application, even if it's dead identical, those material change in circumstances allow that board, your board, to hear this application. There have been many changes in circumstances, physically, legally. Let me count the ways. I think we've explored them already, but I'm happy to brief the board on that if you want. So I think to get back to center point here, we wouldn't bring the same application twice. We certainly wouldn't do it with a neighbor ready to oppose. We're going to do it in a way that we think the board can grant the relief. We're not going to bring a defective application twice. And that's not what we're doing. So,
okay. First of all, with regard to the significant change in circumstances, generally those cases, and I mentioned that in my memo to you, that there has to be a change in the intervening law or a significant change in circumstances. In other words, you change your application somehow to move it a little bit further. Some of the examples that are used out there is out in the Hamptons, where they required them to lower a tennis court below a certain grade so that it couldn't be seen by the neighbors. They were willing to grant some relief, but not to the extent that the applicant wanted. They wanted to depress it was like lower the court 7 feet, and they said, no, we'll do 5. And they kept coming back and forth. Those applications result in substantial changes to the nature of the relief being requested, or are a situation where somebody was denied an application to put a particular addition on a home or a commercial building, or change in the nature of a particular use, but they were denied 22 years ago. But the neighborhood has changed in such a fashion that the relief being requested now is under a different set of circumstances. Wiping off the label of seeking an area variance of 15 feet in a side yard setback in 2022 and coming back in 2023 for the same exact relief is not what the courts deem to be material changes. And if if the applicants wish to put in, proof of that position, that's fine. I am fine with them making further submissions. I am telling you right now, there is no material change. There is no change in the intervening law, and they're glossing over this. Your board is without authority to hear this application. It's simply a regurgitation of a time-barred application, and that is precisely what the courts prohibit you from doing.
Okay.
And I encourage you to seek counsel on that, because I don't think any attorney worth his salt would give you a recommendation to the contrary.
Well, that's certainly something I'm thinking about is, adjourning this matter to next month's meeting, seeking town council's opinion in regard to this.
Yes.
I know, what do the other members of the board think?
I agree.
I think we should hear it, but
You think we should what?
I think we should make an initial determination whether we're going to hear the application. And then we should review the application and how substantial the variance is. So it's a two-part test.
Yeah, I mean, I think, in order to decide whether we're going to hear this application, is it properly before us? Is it time barred?
Well, hold on.
And that's
I don't think anyone, Mr. Singleton, I don't think he's saying that it's time barred anymore.
Yes, I am.
You're still saying it's time barred.
Yes, but not.
You're not accepting.
No,
You're
no,
not
no.
accepting the testimony you've heard tonight.
No, that's not what I'm saying. What I'm saying is it continues to be time barred because submitting this application does not restart the clock. It's time barred from over a year ago.
It's a separate determination. It's a separate decision by the building inspector. I don't see how you can review that under any other circumstances.
Well, then maybe you should see counsel on that because as far as I'm concerned, it's an application for an area variance for a 15-foot setback. No plans have changed. The pool is in the identical location. It was rejected as time barred before, and it's should be rejected as time barred.
It was not rejected as time barred.
Yeah,
Let's put it into that.
I can share with the board the minutes from your meeting in June if you'd like to see them.
Okay, Mr. Singleton, I have a question. For a minute, can we forget about all the legal terms? Can we do that, please?
That's what we're doing.
Okay? What would you suggest for them to do to satisfy both of these complainants? The people that you represent and the attorney here. What would you represent for them to remove the pool? How do we go about this in a neighborly manner, please? What's your piece of advice?
My piece
legal
of
terms. Can you do that?
Yep. Well,
neighbor to neighbor. Talk to me as a neighbor, please.
I will tell you exactly what I told the applicant's various counsel and what I will be happy to provide you written proof of. My clients were willing to give them either a lot line change for which we wanted them to pay for the property. That would have enabled the pool to stay, the deck to stay, and the wall to stay. They rejected it. After they
you're not answering my question. Answer my question. What would you recommend to me as your neighbor that has the swimming pool and you're my neighbor? Please tell, how would you recommend it? Would you like me to remove the pool? Based on everything that is presented to the board, I have moved everything I possibly can, other than the swimming pool for the variance. What would you recommend?
My recommendations would be twofold. One, if somebody made an error, which I don't think an error was made here, I think this was intentional. If somebody made an
Whitney,
error,
please stop representing that. My clients did not intend to put a pool on your client's property.
I'm asking him a question.
I'm sorry.
Let Mr. Singleton finish, please. We can't have all this.
that the party at fault here should pay for the relocation of the pool. It was represented to me by the applicant's prior counsel that they were going after the pool company for damages and that they would pay for everything. So that's one alternative. And I certainly don't think that the Stancius should have to bear the brunt of these mistakes when they did nothing wrong. Alternatively,
Okay, but you are still not answering my question. What would you recommend to me where you and I are neighbors to solve this problem? Forget
Well,
about terms, forget about money, forget everything else.
I would hope that as neighbors, you and I would have sat down in a more productive fashion. How can we ameliorate this situation? And I would tell you exactly what we told the Woos. At their request, we suggested that the fence be changed to natural wood, that landscaping be put in, and that either an easement or a lot line change occur so that they don't need to pursue a variance from your board. They chose not to do that.
Okay, based on everything I have read, they have changed the plumbing, all of the work for the filtration system. I have changed the fence. I'm referring to as I'm the owner. I have changed the fence. The only thing I'm asking for now is the variance for the swimming pool. Now, would you want me to remove the swimming pool and redo that all over? I'm asking you as a neighbor. Forget about the attorney stuff.
As a neighbor, I would like to be able to sit down with you and work out a plan. if I were in your shoes and I built the pool and I built the fence and everything else on your property, I would first offer to remove it all and say how sorry I was for going on your property and keeping you off of it.
And you see why that's a non-starter.
No,
And
because I have been through,
Secondly,
I
secondly, I would
personally have been
ask
through
you,
everyone's shoes here. Okay.
secondly, I would ask you, okay, neighbor, given where we're at here, what have you expended in money? You have engaged counsel for 3 years. You have engaged sets of surveyors. We have broken your drainage system. We have broken your pipes and we have killed your trees. How can I make you whole?
But I fixed all that.
No, you didn't. No, not even close. Not even close. But right now we have a damage.
We're not gonna solve their problems.
I know that.
So, I mean, that's clear. They have a difference of opinion and they're entitled to it.
Yeah, I think the matter before us is to determine whether this application is time barred. I think going to town council and having a discussion with them would be very helpful at this point in time. We're not going to be able to resolve this issue between the parties. They have to decide if they want to resolve it or not. So we just have to, I think, address the matter that's before us at this point in time. I'm not prepared tonight to make a decision on this matter until I talk to town council. I don't know. What are the other members of the board
I think that's prudent.
Yeah, what do the other members of the board think? Really, I want input from everybody as to.
I would like to go to council. Legal counsel from the town.
Well, we can go to council, but that's only going to kick the can down the road.
Well,
Because we're all
council is going to
gonna-
give us their advice. I'd like to hear what
Council's-
town council has
well,
to say.
Yep.
Then maybe we can make a decision.
Well, what decision can we make? We can't make a decision.
Sure we can.
The decision is for these two parties to quietly settle this thing. $27,000 is not all the money in the world. And I'm sure if this gentleman over here thinks that he is in the hole for some amount of money, and this gentleman over here agrees with him, they can come to some agreement between them to settle that amount of money. And this whole thing goes away.
And then,
Then you
I
can
think
come
our-
back to us and ask for a variation on how close the pool is to the existing property line.
our decisions may well expedite that negotiation, I think, once.
I hope
once the-
so.
Once these votes are in. But I think this is probably going to have to happen first. I have no objection to seeking advice from council.
So my objection to seeking advice from council was that when this matter came before us last time and council provided us advice, he was also the town prosecutor on the matter.
Right.
And
I think you raised a very good point. I could speak to that if you want, but I'll let you finish.
no, I mean, there have been other, after that happened, I spoke to a couple of people who operate in a similar sphere. And I know Mr. Caruso is a town judge as well. So we'll probably speak to it a little bit more eloquently than I can. But for me, there's a conflict there with the very person who's prosecuting them is providing advice to the same board. And so I hadn't seen that before. In that very specific manner when it's concurrent.
Well, I do think the situation calls for special counsel. And I think Mr. Lansky makes an excellent point, which is there is a conflict that could exist. Your prosecutor in a code enforcement action is the same individual and attorney who's rendering advice and counsel to this board.
Right.
And I'm not, Jerry is a fine lawyer, and I'm not saying this is not a judgment on Jerry. This is the board's decision to weigh. And I think Mr. Lansky makes an excellent point, which is the board should consider what wearing multiple hats within the same town in different departments constitutes in the view of a perceived conflict or an actual conflict. And that is a serious consideration that needs to be determined and weighed carefully.
I mean, we can go to council outside of town council.
We
don't have to.
We can't, but I think.
And we have before. It has occurred.
But Vic, this matter breaks down to whether or not this is the same application.
Right.
And so there's a couple ways to look at that. One way is, did the building inspector look at it that way? And did he provide us a similar denial letter? That's one viewpoint on that. Another viewpoint on that is Mr. Singleton's, which I believe is they're asking for a 15-foot setback. That's what they asked for before in some part. and therefore it's the same application. But so that's what it comes down to. The special counsel or regular counsel, they can review the cases on that and talk about what are different circumstances. It can be whether or not things have changed. The Wu's removing things and their neighbors removing things. Does that make it a different application? Has it, now that they're off the property, is it a different application? But I think, you know, our board can discern that to some degree on its own. I don't think town council is gonna be able to distill that down to the letter.
I don't
So
know
that's
if I
where,
could-
that's where I am.
I don't know if I can make that decision though, without looking at the case law, you know, to actually see what, you know, what decision has been made with these cases in the past. Is this a different application? You know, what constitutes a different application?
Okay.
You know, so.
We can ask for a brief on that.
Yeah.
We can ask for a letter of advice on,
I mean,
whether this is specifically a different application.
I mean, I think
I
that's the
wouldn't
crux of the
just
matter.
go ad
Yeah.
nauseum, and I wouldn't go to the prosecutor.
Right. We could, if you feel there might be a conflict there, then certainly we can go to, you know, other counsel that's independent. Sure.
I felt there was a conflict when the prosecutor came before us last time
Okay.
on a matter that was in front of him.
Can I weigh in a little bit?
Sure, Whitney, go ahead.
That's not an unusual situation, and that's not an unusual concern that municipal attorneys that wear multiple hats somehow are perceived to have a conflict of interest. It's not unusual for a town board to sue a zoning board, in which case the town attorney, who might sit with both boards, has to recuse himself. So I understand and appreciate that, but I don't think the mere fact that you have a municipal attorney representing the interests of more than one board or more than one interest is per se a conflict. But if your board feels as though it is and is able to get alternate counsel, that's certainly within your purview. But I don't want to disparage your town prosecutor by saying that him wearing two hats is improper, because that's very commonplace.
But, sir, in this specific instance, what the applicant was trying to do was to go to the zoning board as a way of curing the violation from the town prosecutor. And then the town prosecutor is providing advice to the zoning board that he shouldn't be allowed to come in front of the zoning board, which would cure the violation.
No, Mr. Lansky, I understand that, but the issue of why he couldn't come before the zoning board to cure the violation was because he sat on his hands for too long and did not make a timely application.
That may be, but there still is, I still have an issue with the same person on two sides of it.
And that's your prerogative. I'm just saying it's not unusual. I don't want to make it sound like.
And if it's not, and they're operating in that sphere, I think that's a perceived conflict.
Okay.
And that's what the law says, a perceived conflict as well as an actual.
The appearance of a conflict, correct.
Okay.
Is there not a separate town attorney?
Sure there is.
Yeah, there's other attorneys that have been used, yes.
And I'm more than happy that the better the zoning attorney you can get, the happier I am.
That's what we'd be looking for, so.
Well, from the applicant's perspective, I have to agree with Mr. Lansky that the attorney who was driving the stipulation and the ACD terms that were agreed upon in the Justice Court, which provided for certain remedial action to take place, would probably be more than an appearance of a conflict in advising this board on threshold matters and substantive matters related to this application. So I think Mr. Lansky is well within sound judgment in raising that point on not one, but two occasions. So I would.
Okay, I don't know if we're just going to keep rehashing. What I think I'd like to do is just take this out to the public and see if there's anybody else present or online who'd like to speak in regard to this application. So is there anybody here who wishes to speak in regard to this application?
It's too much to speak, I think.
Sir, if you would like to speak, please just, sir, you have, if you want to say something,
Have to go to the
you have to go to the microphone. Yeah, please go to the microphone and give us your name and address, just so we know who you are, and please tell.
My name is Annie Stanciu. I am the neighbor that lives at 4 Silver Springs Court in Katona. And a lot has been said, and in legal terms, in applications, reasoning for the giving the variance or not giving the variance. But what I want to say is this. As soon as we discovered the encroachment that was in our property, which, by the way, is not cleared until today. We speak here, as you saw in the pictures, the poles from the fences, they still on the ground. Our property is damaged. As the inspector saw, pipes are sticking out of the land. Fences still in the upper part of the land, they still there. Trees are falling apart.
Sir. Hold on.
One person.
Trees are falling apart. Our driveway, which is next to the place where they put the pool, it's start to crack. All the cracks you can see because the drainage has been damaged. The water from the mountain is not going to the proper way where used to be a PVC pipe that all the water was going all the way to the drainage. So that is covered, it's blocked, and all the water is coming our driveway, which the ground it's being sanded and moved away. And we incur so many damages to our property. But I wanted to say is when we first discovered this, because we used to have a very good relationship, we called them and we showed them, look what is happening here. Please remove your fences and let's fix this situation now. They refused. The inspector is here. How many times I had to come to town until they were able to give them the violations? For 1 year, they were in court trying to dispute the property line, even though 3 surveys were presented, ours and theirs too, showing exactly what is the property line. They were trying every single way to cover what they did wrong and what they knew, because they had a survey in January 2019 showing clearly what is the property line and showing clearly that in 31 feet property that they have, they cannot build a 45 feet project that they submitted. So as a neighbor, because you asked me, you actually asked my attorney, we were trying to solve this from the very beginning. They refused. We had to go to court. We had to hire surveyors. We had to encounter legal fees for more than a year, for more than 3 years, to defend our property line, to defend our property rights, to defend our land. So that is what I wanted to let you know, because we are here not because we wanted, because of them wrongdoing.
Okay, thank you.
Can I say something?
Sir, just give us your name.
My name is Panta Stanciu.
Right.
I've been honest with them like my kids. I treat them like my son. I call them in my house. I put food on the table. I put drink on the table. I say, let's resolve this without lawyers. Just they look like me, at me, the way you're looking at me. Didn't answer nothing. I wait months. Storm come, the water come, start to destroy my property. When they build the pool, they hammer the stone, they break the stone. After they finish, I go on my garage cracks. I go on my foundation cracks. I didn't realize why. There's cracks in my house. Why is coming this cracks? When we find out what's then I call engineer and I ask, why is this? Say when they dig the pool, shake and start to crack. They crack a little bit. Now it's crack half inch. Next year is going to be 1 inch. 2 years from now, who knows how big is my cracks? I have hundreds of $1,000s damage. I didn't chase them for my damage. I chased them what I spent. I didn't want them 1 penny from who. I say, I don't want your money to curse at me for your money. I don't need your money. I work hard. I move here. And this property, because I work hard, I'm not a crook. Just leave me alone. Move RF from my property and leave me alone. They wanna. They treat me in any way. They feel like I'm a dirt. For what? I didn't make nothing wrong. I have a lot of damage. Now I'm gonna sue them for all the damage what I have on property. They want to play this game. I'm gonna show them how they're gonna play the game. I'm done.
Will you allow them to come take the rest of the stuff off your property if there's still stuff there? But is that okay?
They had a court order to remove all the encroachments.
Yeah.
And they're supposed to submit a plan to be approved and to show how to do it and to ask for permission, how they're gonna do it. They did nothing. They wait until we left our house to go to work, and they hired the contractors, and they were working during the day after we left purposely, so we'll not be home. I had to call the police for trespassing, and I have police report because they were in my property without my permission. And the inspector is here, he knows, because I called him and to show him what they are doing, ask me if they have any plan of how they're removing the encroachments and how they are going to rebuild my damaged property.
They stole our stairs.
But at this time, if they had a plan and they provided that, and they had a contractor with insurance, would you allow them to finish the removals?
We were right there, and when the inspector was there, they promised they're gonna do it. They never do it because you know what? They don't respect us as neighbors.
I'm just asking from going forward.
I'm more than happy to. I felt so disrespected. How you will feel if somebody will come to your property, do the work they feel like it, after they encroach your property with 60 feet, and they don't even bother to ask your permission. That is outrageous. Yes, I will do because I want this to be settled. I want my land to be recovered to the initial form, but they don't have the respect.
So I think what I'm hearing from the board is that we're probably going to go to an attorney, and which means you're probably all going to be back here in a month. And if they provide you with a plan and with insurance, it'd be great to know that there was some progress made.
We were open from the very beginning. That is what I want you to understand. We didn't want to go this far. We saw a problem, let's fix it. They refuse it. Actually, I don't know, like they mentioned, we told them from the beginning, we don't need your money. We don't need anything. Just remove your stuff.
Today, the lawyer cost $2,500.
Okay, so Mrs. Wu, go let Mrs. Wu say, come up.
I don't know.
For what?
Okay, yeah, we have to talk on the microphone. Everything has to be as a public record. Okay. All right. All right, ma'am, do you wish to speak in regard to this application?
Mrs. Wu is going to keep it brief, but just so the board is aware, the survey that's in our application packet, Mr. Lansky, right here, this is the plan, so to speak. This shows the work that was actually done. Building department, please, this was submitted.
No, please, no arguing, please.
We're not filing plans with the neighbors. The building department reviewed it. The people did the work. That's what happened. And they're 95% done with it. So that's.
Yeah.
Yes, people, they do the work in their property. They cannot file papers for somebody else's property. Can they? No. What is their property right?
Okay. All right. Ma'am, if you want to come up, yes, please give us your name and then.
My name is Deborah Wu. I live at 8 Silver Springs Court. We've been there for 16 years. We moved in 2006. In 2007, we hired contractors. We went to the town. Everything was approved. We put in a whole new patio. I have pictures showing where we had a fence put in. Everything was done before they moved in. There was a wrought iron fence where the new fence was now. They moved in. We used their driveway to have the pool put in. I asked permission. She said yes. I happen to have pictures of the driveway in its state in 2019 in case the crane would break any of their pavers that we would replace. There was no damage done. So I have pictures of the cracks that they're talking about from 2019. I also have pictures from 2019 when they bought the house, before they bought the house, a tree was already tilted. I know for a fact the landscaper that we share asked them, do they want to fix that tree? And they said, leave it. Now they're blaming that it's our water that has caused the tree to fall. It has been there before they moved in. The tree was like that. Their garage, their driveway is the way it is from when they moved in. I have pictures to prove that. Everything that we did through the town with our backyard was approved from 2007. We put the survey that we gave to the pool people, a reputable company. We brought it to the town, the site plan. They approved the site plan. We went in. That bait and tackle nonsense that he was talking about was not done before the pool. What is that sight line from their surveyor that we're not objecting to was done after the pool was put in. They liked the way the land looked and everything looked, but because of COVID, our privacy fence was on back order. So our plan with the whole pool was to have a privacy fence. COVID hit and everything stopped. When the pool, my husband almost died. He was in the hospital. And when he came back from COVID, I begged the pool people to please, for his birthday, to be swimming to sit in the pool. He could barely walk from the pool, from our backyard to the pool. But on his birthday, 3 stops with oxygen from the disease, he was able to sit in his pool. We had to have a temporary fence because the white fence that we ordered was back ordered from COVID. Once that fence was put in, we went to their house to eat. They came to our house to eat. We were friendly neighbors. Once the fence was up, we had them over. I have everything documented. I have books, I have dates and pictures. And they said, you don't like us because you put up this fence. We said, we're sorry. What are you talking about? It's a privacy fence around the pool. Then they showed that it was off, it was on their property. We said, okay, we'll fix it. We said we'd buy it. He said, I don't want your money. I have enough money. So with that, we had the survey. When the survey came then, they said, we'll move everything from your property. He said, okay, no money, no nothing, just move it. The very next, they went to a gentleman's agreement. It was February of last year. I have proof. They shook hands at their house. My husband went to their house. They would shake hands. We would move everything off their property and we would be done. They would give the variance. Then all of a sudden, the very next day, they want money for broken pipes, which we were the pipes that we had put in. I'll show you where they're talking. We thought was our property from 2007. They're saying we ripped up sprinklers. They never had sprinklers. I have proof. I've been there 16 years. That was the dirt that we gave them to fix their yard from my pool where they got a sprinkler pipe. I have proof of this also. Many times, then they say they wanted money to buy. It wasn't just $100,000 to buy it. It was, and I have proof from Mr. Singleton that he wrote, it was $100,000 to purchase plus fix sprinklers that are broken that do not exist, plus fix their basement or their driveway or whatever, which isn't because of my pool. And I had to spend an extra $4,000 on a topographical survey to prove that if your house and your land is up here and mine is down here, water does not go uphill to damage your property. But never did it come to, when we spoke, did it say, okay, well, I'll do this and you do this. It's my way or the highway with them. We tried and we never was in a rebuttal. And at this point, we're begging for the town, for the board to please help us. We did everything by the book for 16 years to please give us the variance. We moved everything at our expense. When we went out on last September, they went and destroyed my fence that, yes, it was, we figured out it was on their property. $10,000. They didn't just say, can you take it down? I'm done. Because they said no lawyers. They went to a lawyer. They brought this to the lawyer. We didn't go to lawyers. So now all of a sudden we're in this conundrum. I'm asking, we've done everything by the book for 16 years. We spent tens of thousands of dollars removing everything off their property. They cut my fence down. When we left, my 14-year-old son was home by himself, called us a panicking, Mom, they're ruining the fence. And he videoed it. And we moved all past that and put everything on a property. And now you want me to move the pool on top of it? Please, we're asking for your help here. A lot of these lies, I can't take and sit quiet anymore. Honestly. Thank you.
Thank you.
Chairman, can I share one thing that's germane to your discussion as opposed to what's going on in other properties?
Sure.
If you don't mind, I'd like to share my screen for a second and show you the survey that we're talking about.
Okay.
Your host is disabled screen sharing.
It should be good now.
Okay, thank you. Okay. As you can see here, this is where the pool is now. This is shown after the fact. This was put in recently, but you can see there were hub and tack, not bait and tackle, shown here, and these were existing from prior applications. But before the pool went in January of 2019, they hired Insight Engineering to put these hub and tacks in. So these needed to be physically removed in order to put the pool in the setback. So to say that they didn't know is simply a fallacy. Those stakes were in the ground. They were put in right before the pool went in, and they were on notice that was going to be in the setback. I submit to you that they put it in on purpose, like they did everything else, and they have misled your board, and that they should not be rewarded by being granted a variance to put in a pool that adversely affects my client's use and enjoyment of their property. It's done in this fashion.
Sir, isn't it? I don't think Mr. Wu actually put the pool in. He hired a company, Nijam, who brought out laborers. I calling it intentional and saying that he purposely did that. I don't think there's any need to do that. That's not that. We don't have that standard here.
Okay, well then
I think the standard is
the relocation.
I think the standard is whether there was a material change in the aspects of the case or substantial change of circumstances since the last application. I think that's what we're talking about now.
Agreed.
As our threshold standard.
Yeah, because we're getting into all these
so,
other.
So I think Mr. Singleton agrees. I don't know, Mr. Caruso, if you agree if that's our standard. Whether there was a material change in the aspects of the case or a substantial change of circumstance.
Yeah, if the board is going to take the position that this is the same case that was just,
we're asking,
regardless of that,
we're taking the position that we want to have counsel review this. And I'm saying that my reading is the delta here is whether there was a material change in the aspects of the case or substantial change of circumstances based upon my reading of the law.
Right. If the cases that support changes in circumstances, as you recited, Mr. Lansky, I think we agree, stand for that proposition. The board can independently identify and assess whether the appealed from decision or order is different as against that standard or as it sees fit.
Yeah, I just don't see that this board wants to do that. So that's what I'm seeing from my members is they want to get further advice. And that's what I'm seeing as the standard. And I'm seeing Mr. Singleton saying that's the standard, and pretty much you saying that that is the standard, but the board makes that determination.
Yeah, the board's in the position with the building inspector here to ask whatever questions it sees fit about that determination, that decision. Mr. Tuma can speak to it. It's in his hand. It's his letter. The board can interpret that whatever way it pleases. But our position is we wouldn't be here unless that was a different order and materially and substantially changed. And that's our position.
And I think there is some merit to the fact that we have a different denial letter on this application versus the other application. There is some in terms of things being different, but I don't know that that goes all the way. That's for the whole board to review.
Right.
I don't believe it does, but
yeah,
I'm certainly happy to take additional advice on that.
Yeah. I'd like to seek additional advice at this point in time before I make a decision.
I agree.
So I'm going to email that sentence to Denise, and then I assume she'll reach out to hopefully another attorney besides the prosecutor.
I have no problem with going to independent counsel, so to speak. Yeah.
Okay.
Sure.
But to be clear,
I think that's reasonable.
To be clear, on the issue of whether it is a separate and distinct order or decision that can be appealed from, that's a standard that can be applied. There's cases that will articulate that standard for the board. But regardless, my point was previously, if we brought the exact same application, seeking the exact same relief, as they did in the Palms case, which is not what we're doing here, but nonetheless, if there had been changes in the law, as Mr. Singleton identified, or substantial changes in circumstances factually between the first and the second identical applications, this board can nonetheless hear that second application as a new one. That is entirely within their discretion, and that there's plenty of law on that side. So,
and I'm seeing the change in circumstances quoted in the decision, which is quoted in Mr. Singleton's letter. So that's part of that question that we're asking.
Yeah,
it's a two-part question.
Right. I believe one of the prevailing cases in the second department is a matter of Blum. But we can provide that to the board, at its discretion.
I mean, keep in mind too, when we seek, another opinion, there have been times we've sought opinion from town council and sometimes not gone with it. Okay. So, we're going to listen to what an independent counsel says, and we're going to, look at these. I want to look at the facts and circumstances more, and then we're going to come up with a decision.
No, we appreciate the board being very flexible and open-minded. And I've been on applications where the board has done just that and has been guided and made, objectively reasonable decisions. So we appreciate that from the applicant standpoint.
Okay.
So
I think to rehash some of these, who said this and that, I don't think that's really getting us anywhere at this point in time. That's between the parties. If they want to resolve it, fine. But that's, so I think at this point in time, I'd like to, is there anybody else here who wishes to speak in regard to this application? No. Paul, do we have anybody online who's come on? So once again, I'm going to say, anyone from the public who's listening can come on and speak in regard to this application. Simply call one of the numbers in the white box, put in the Zoom meeting ID number, and you can come online. We'll just leave it up for a minute and see if there's anybody else interested in speaking in regard to this application. The more board members want to have any further discussion with this? I mean, are we to the point where we're, I think, in agreement to seek outside counsel?
Yeah.
And then we can go from there. I mean, I think that's the most prudent course
Yeah,
of
so
action.
I emailed that one sentence to Denise, whether there was a material change in the aspects of the case or a substantial change of circumstances. And that's what I believe an interpretation that we're looking for.
Exactly.
As a threshold, and then we review whether or not we agree that the variance is substantial or not.
Right.
And I trust that who's ever reviewing this will get the benefit of our submissions to date.
Yeah, of course.
Oh, yeah. We want to provide them with everything that we have. We will provide to them.
And if there's anything else directly on this point, it's fair enough. I'm sure we could give a couple of days.
Yeah. I mean, if either side wants to present additional documentation at this point in time, I mean,
It'll make it easier for council to provide.
Or even maybe settle it between you both.
Well, that's between them if they want to do that.
I think that if you notice that we'd love them to settle the matter.
I mean, if we have to make a decision, we'll make a decision. That's it. We've made difficult decisions before, and we'll do it again.
How I look at this, there's no winners.
When do you want this?
There was no winners the second they put the pool in.
Yeah, there's a Hemingway story.
Yeah, how about we say a week from today? Would that be okay? If you want additional comments from both sides,
Yeah,
if you want to address any of the other issues that haven't been addressed, we're going to provide everything to the council, and then we'll get his or her opinion, and we'll go from there.
yeah, we don't want to be in front of the board with a winner take nothing scenario. We come to the board with an application we think was reasonable, and we'll do everything we can to communicate with Mr. Singleton. And if there's a way to resolve it, we will continue that end. We'll try to make the boards lift a little lighter if that's possible.
Sure.
Thank you.
So,
Thank you.
Sure. Okay. Paul, we don't have anybody else coming on? No, we have no one else who wants to speak in regard to this application. Okay, so this matter is adjourned to next month. Please do inform us if there is a resolution, but we're going to proceed to outside counsel and we'll go from there. Okay.
Thank you.
Okay.
Thank you for your
Thank
time.
you, everyone. Thank you. Okay, good night. Last item on the agenda this evening is the approval of the meeting minutes from January 17th, 2023. Has everybody had a chance to review the minutes?
I have to excuse myself for the vote.
Okay.
Yes.
Any changes to the meeting proposed?
No.
Okay, I'm just gonna, by voice consensus, all in favor of approving the minutes?
Aye.
Anybody opposed? Nope. Okay, Denise, our meeting minutes for January 17th, 2023 are approved.
Excuse me, Vic, just Arnie, you recused yourself, right? Everybody else was good?
Aye. Correct.
Correct.
Thank you.
I will also make mention that our next meeting is March 21st, 2023 at this location. I don't believe there's any other matters before us. Anything else we have to discuss before we adjourn the meeting?
Are we going to meet with this attorney?
Probably not me, but we will certainly get a written opinion from the attorney regarding the matter. I'll speak with Denise. We'll find acceptable counsel and provide all the documents. So, and then we'll get an opinion and then we'll go from there.
With two submissions, he'll have all the cases cited and it'll be less research for him.
Right.
So that's giving him time to provide a submission is helpful.
Right. And if for some reason we can't get a decision by next month's meeting, we'll have to adjourn it. I mean, till the following month.
We should be able to.
Yeah, hopefully.
It's
Hopefully.
not that much.
So, okay, if there's no further matters, I'm going to adjourn the meeting. Are we all in favor of adjourning?
Aye.
Favor? Okay.